SwayamPrabha. Digital India. Educated India.
Hello friends, I welcome you all the viewers in the fourth session to the course Law Relating to Women and Children. In this fourth session of this course, I have come with the topic Protection of Women from Domestic Violence. In this lecture, I will discuss all the aspects of the domestic violence against women and the laws protecting the women against any kind of domestic violence. Friends, the domestic violence, domestic violence against the women has been the worldwide phenomena, and this domestic violence against women is responsible for physical, sexual, emotional and economic torture to the women, which results into the impediments in the path of the inclusive development of the half population of human race. The domestic violence has become one of the most persistent causes for the violation of basic human rights of women. According to the United Nations Declaration on Elimination of Violence Against Women, General Assembly Resolution December 1993, violence against women is a manifestation of historically unequal power relations between men and women, which have led to domination over and discrimination against women by men and to the prevention of the full advancement of women. It is also the hard fact that women are subjected diverse kind of violence when this violence occurs within the boundaries of home and by the close relatives. It is termed as domestic violence. So, when the violence is committed within the boundary of the home and when it is committed by the relatives of the woman, it is called as the domestic violence. It was the later 19th century when the issue of domestic violence came to be recognized as an important women issue by the researchers and scholars doing their work in the field of law and social science. Some of them find the nexus between socio-economic conditions and domestic violence. Others observe that low esteem gender inequality and social and economic reliance of wife on husband and in-laws results in domestic violence against women. So, these researches done by the scholars, done by the legal researchers, these considers two important reasons for the domestic violence. One is the nexus between the connection between the socio-economic conditions and domestic violence, meaning thereby the incidences of domestic violence are relative to the socio-economic conditions of women, and others are of the view that the gender inequality and social and economic reliance of wife on her husband and in-laws results in domestic violence, meaning thereby the second group, it takes the gender inequality also as the reason of domestic violence. The social and historical facts that stipulate the structural and ideological role of men and women in the society, it may also be considered as a cause of domestic violence. the stereotyped roles are defined of men and women in the society, and it has been established that these are the roles to be done by the women and these are the roles to be done by the men. That has also been the reason, because generally the women or the educated women particularly, they do not accept this stereotyped role, that they are made only for the role within the boundaries of the family. They cannot be the part of the social gathering, they cannot the part of the social services, etc. And these stereotyped roles are not admitted or accepted by the educated women, and that has also been reason for the domestic violence against women. The Indian society has been infused by the notion that woman is the property of her husband. This could also be the reason that gender equality could not be recognized in Indian society, despite the mandate of our constitution to guarantee equal rights to all citizens of the country irrespective of their caste, race, place of birth and sex, etc. Though on the basis of the sex, the discrimination is not allowed by the Indian constitution, and in accordance to the mandate of Indian constitution, the women and men are equal, but the traditional approach of the Indian society has been infused with the notion that the woman is the property of man. That has also been the reason for the domestic violence. And it seems that there are several reasons, there are innumerable reasons for manifestation and existence of domestic violence against women, but among all these reasons, the power and control over the resources, it seems to be the central cause or the central reason. It happens because of physical and economic dependence of women on their male counterpart, and therefore, there are the instances of domestic violence. One more social reason for the domestic violence against the women may also be the alcoholism or aggression or deficiency in civilization and socialization. The poverty may also be the reason, the backwardness may also be the reason, the non-enlightenment is also the reason, and the lack of the awareness of the laws is also the reason for the domestic violence against the women. So, there are many reasons for the domestic violence being committed against the women, but the researchers have shown that the central reason or the central cause is the power, the imbalance of the power and imbalance of the resources between the man and woman has been the central cause for the incidences of the domestic violence against the woman. If we see the Indian situation, in India, the majority of victims, they do not seek the legal remedies because they are economically dependent on men, they are educationally backward, and therefore, they are not sufficiently aware of the laws, they are not sufficiently aware of the procedures, and they are confined within the boundaries of the home. They cannot go out for seeking such legal remedies. That has also been the reason for the persistent incidences of or the consistent or continuous incidences of the domestic violence. With regard to the domestic violence against women, the several international and national initiatives have been taken. Several international instruments have been agreed to by the international community, by the member countries. Several national laws or the laws at the level of nations, and particularly in India also, the several laws have been enacted to protect the women from such kind of violence. Within the IPC, in earlier lecture we have discussed that there are several provisions to protect the women from any kind of such violence. But for a long time before 2005, there was no specific law to provide for the remedy against the women in as the civil law. Several international and national initiatives have been taken. If we see that during the time of assumption of CEDA by international community, CEDA is the United Nations Committee on the Elimination of Examination against Women. CEDA is the convention for the elimination of all kind of discrimination against women. So, during the time of assumption of CEDA by international community, when CEDA was agreed to, violence against women mainly in the private sphere was mostly understood to be a private issue. That is the important point. It was neither considered as a matter of international attention nor a human right concerned, and therefore, under CEDA the private life could not be at the time of assumption. The incidences of domestic violence and private life of women, these were not being considered to be the matter of the international consideration or the matter of outside consideration. On the other hand, the courts and the experts bodies have been interpreting the obligations of member states arising out of international human rights treaties to require them to take appropriate measures to prevent infliction of violence, to investigate and punish such acts, and to provide protection and support for the victims and survivors of violence against the women. See, the United Nations Committee on Elimination of Discrimination against Women, in its general recommendation number 12, which was made in 1989, and number 19, which was made in 1992, to the member states of CEDA. CEDA was agreed to in 1979, and these general recommendations were made in 1989 and 1992. To the member states of CEDA has recommended that state parties should act to protect women against violence of any kind, especially that occurring within the family. So, these resolutions played an important role to cover the violence against women within the family, the violence against women within the boundaries of the house, because at the time of, as I told you that at the time of assumption of CEDA, the private aspects or the private affairs of the life were not considered to be tackled or to be dealt with by international instruments, but when it in 1989 and 1992 these two resolutions were passed by the member state, then the domestic violence against the women or the violence against the woman which is committed within the boundaries of the home or within the family was also considered to be taken into account or to be dealt with by the international instruments. Other human rights treaties or other human rights treaty bodies of United Nations, such as Human Rights Committee and Committee Against Torture, Human Rights Committee and the Committee Against Torture have made clarifications that obligation of member states under the International Covenant on Civil and Political Rights ICCPR and the Convention Against Torture and Other Forms of Cruel, Inhuman or Degrading Treatment or Punishment 1984 embrace the elimination of public and private violence against women. That clarification was made. Now, see the development of international law. In 1989 and in 1992, the General Assembly to the United Nations passed the resolutions to include the domestic violence or the violence against the women within the family as a matter of consideration by the international community, by the international law, by the international conventions, by the international covenants. And then the Human Rights Committee and the Committee Against Torture also made the clarification that under these two conventions, this is the responsibility of international community, or the domestic violence within the family is also included within the scope of these international instruments or these conventions. Embrace the elimination of public and private violence against women, meaning thereby that the International Covenant on Civil and Political Rights and the Convention against Torture, these two conventions or these two international instruments are covering the violence against women even when it is committed within the boundaries of home, or when it is committed within the family, or when it is committed during the private affairs. Then the regional human rights bodies like Inter-American Commission on Human Rights, the African Commission on Human and People's Rights, and European Court of Human Rights have also concluded the same and made similar recommendations that the violence against women within the home, the violence against women within the family should also be considered by the international community, should also be dealt with by the international instruments like CEDAW, like ICCPR, like the Convention against the Torture. And the issue of, or the matter of, the domestic violence or the violence against women within the family, violence against the women within the boundaries of the home is not out of the scope of these international instruments. So, by this development, the international law also took care of the violence against women which is committed within the family, or took care of the domestic violence against women. The United Nations General Assembly took up the issue of domestic violence against women for its consideration in the year of 1985 and requested the 8th United Nations Congress on the Prevention of Crime and Criminal Justice through its General Assembly resolution number this, for giving the special attention to the issue of domestic violence. And then in the year 1987, the United Nations Commission on the Status of Women identified violence against women within the family and society as an important issue to be addressed by the international community with some effective initiatives. The Commission also convened a meeting of an expert group in 1991 to think about the options for consolidation and solidification of international legal framework to protect the women against domestic violence. After these serious concerns and efforts by United Nations Economic and Social Council and the Commission on Status of Women, UN General Assembly adopted the general recommendations on the theme by CEDAW 1992, the Declaration on the Elimination of Violence against Women 1993, the establishment of a special rapporteur 1994 on the subject by UN Commission on Human Rights, and the adoption of the procedural optional protocol to the CEDAW in 1999. At international level, the Vienna Accord of 1994 and the Beijing Declaration and the Platform for Action 1995 have also acknowledged domestic violence as a human right issue. Thus, at international level, within the scope of international law, the domestic violence could be recognized as the matter of concern, or the domestic violence against women could be considered as the human right issue. Up to this development of international law, the human rights, the domestic violence against women was started to be considered as the human right issue, and therefore, the international community was agreed on the point that the issue of domestic violence against women should also be tackled, or the women should also be protected against the domestic violence by the international law, or the international law should also make the efforts, and thereby such efforts have been made by the international community to protect the women from domestic violence. After discussing the international law relating to the domestic violence or protecting the women from domestic violence, it is also important for us to see the constitutional provisions or to see our constitution, what provisions have been included in the constitution itself to protect the women from the domestic violence or incidences of domestic violence. If we see the constitutional mandate or the mandate of the Constitution of India, we find at first place Article 14. Article 14 of Indian Constitution prohibits any kind of discrimination on basis of sex and ensures equality opportunity. As I have already told you that the incidences of domestic violence, these have always been the impediments in the development of personality of women, and they could not avail the opportunity of development or they could not avail the right to development equally with the men, and such a situation seems to be violation of Article 14, and therefore, Article 14 also plays an important role in the protection of domestic violence against women. Then Article 15(3) of Indian Constitution is also one initiative on the part of the makers of our constitution by realizing the position, the status of women in Indian society, that the state should be authorized to take some special measures, some special initiatives to protect the women from any kind of discriminatory situations or any kind of such incidences against the women, and therefore, Article 15 clause 3 authorizes the state to take the legislative and executive initiatives against the incidences of domestic violence. It means that the Indian legislature could make any effective law also for protecting the women from domestic violence, or it could take some executive measures in this behalf. The right to life and personal liberty, Article 21, that is considered to be the most important provision among the provisions found in Part 3 or fundamental rights. Article 21 of Indian Constitution talks about right to life and personal liberty. Right to life and personal liberty, when it was interpreted by the Supreme Court in different cases, this right to life and personal liberty includes the right to live with human dignity. The interpretation of Article 21 has been made very broadly. The expensive interpretation was made of Article 21, and it was found by the Supreme Court of India during making the interpretation of Article 21 that the Article 21 is the repository of, it is the source of many fundamental rights which are not explicitly or which are not clearly mentioned in Article 21. By interpreting the term life, right to life and right to personal liberty, the many new rights have been included by the judiciary, by the Supreme Court of India as a part of right to life and personal liberty, and among these different new rights, new fundamental rights created by the Constitution as per the interpretation of Article 21 also includes the right to live with human dignity, and every person is entitled, because Article 21 states that no person shall be deprived of his right to life and personal liberty. When right to life and personal liberty includes within itself the right to live with human dignity, and every person is entitled to this right to live with human dignity, then again it can be assumed, it can be concluded that the women are also entitled to this fundamental right to live with human dignity as a part of Article 21, and whenever there is any denial of this right to live with human dignity to the women, it would be the violation of Article 21. The Article 21 has been constituted by the Supreme Court of India to include within the ambit the right to be free from any kind of violence, right to shelter and right to live with human dignity. In the case of Francis Corelli Moline versus Administrator, Union Territory of New Delhi in 1981. So, see that the Supreme Court of India in 1981 recognized the right to be free from any kind of violence, right to shelter and right to live with human dignity, and therefore, this is the right against the domestic violence. It has also been held that the right to live with human dignity includes the right against any kind of inhuman treatment, the right against subjection to any kind of humiliation and the right against any kind of insult. So, when the right to live with human dignity includes the right against any kind of inhuman treatment, right against subjection to any kind of humiliation and right against any kind of insult, then certainly the right against domestic violence is recognized by the Supreme Court of India by making such interpretation of Article 21, because in the incidences of domestic violence, the woman is always subjected to humiliation, the woman is always subjected to the insult, the woman is always subjected to the inhuman treatment, the woman is always subjected to the violence, the woman is always subjected to the indignity of her person, and therefore, it is the clear violation of Article 21, and therefore, it seems that it is the constitutional mandate under Article 14 and under Article 21 that the woman should not be subjected to any kind of violence, including the domestic violence. These all the dimensions of life definitely refers to the incidences of physical abuse, sexual abuse and emotional abuse constituting the act of domestic violence. Any act of physical abuse, any act of sexual abuse, any act of emotional abuse always constitute the act of domestic violence, and therefore, Article 21 protects the woman from any kind of domestic violence. Further, we can see Article 39A. Article 39A of the Constitution directs the state to provide adequate means of livelihood, and under Article 39D, the equal pay for equal work for men and women both. As we know that one important reason of the domestic violence is the imbalance of power and resources, and if the right to adequate means of livelihood and right to equal pay for equal work is recognized by the Constitution, then certainly it will help the woman from being free to be free from the incidences of domestic violence when such the power and resource imbalance would be removed. Under Article 39E, the Constitution requires the state to ensure that the health and strength of women are not abused and they are not forced to enter avocations which are not suitable for them. Finally, the Constitution imposes the fundamental duty on the citizens to renounce practices which are derogatory to the dignity of the woman under Article 51A. So, this is the constitutional mandate on the issue of domestic violence. Then we are to see the criminal law provisions. What are the provisions in criminal law to protect the women from domestic violence? Prior to the enactment of the Protection of Women from Domestic Violence Act in 2005, the options for victims of domestic violence in India were limited only to the matrimonial remedy of divorce under civil law or the criminal sanctions under the Indian Penal Code. which is now termed as or named as Bharatiya Nyaya Sanhita 2023. A woman's options were further limited because criminal sanctions are only available if abuse involves extreme cruelty or dowry related violence. So, for the domestic incidences of domestic violence, the options of the women were limited only to the remedy of divorce in the civil law and some criminal law provisions or criminal law remedies, rather the provisions of criminal law. But this is the difficulty in taking the remedies and receiving the remedies in criminal law or to invoke the provisions of criminal law, that the criminal law is always applicable on the basis of mens rea. For proving the offence or the crime on the part of any person, the intent of that person to commit the crime is also required to be proved, and it is very difficult to establish the mens rea of a person in committing any offence, in committing any act. And therefore, the provisions, the option which was in hands of the women to invoke the criminal provisions or the provisions of criminal law was further limited because of this particular aspect of criminal law. In 1983, the amendment in criminal law were made, and these amendments were made because of one very such an insulting incidence known as Mathura rape case. After the decision of Mathura rape case by the Supreme Court of India, the criminal law amendments were made in 1983, and the expression cruelty has been defined in wider terms so as to include the infliction of any physical or mental harm to the body or health of the woman, and indulgence in acts of harassment with coercing her or her relatives to meet any unlawful demands for any property or valuable security, creation of situations driving the woman to commit suicide also come within the sweep of section 498A. The offence of dowry death, that is section 304B, which we have already discussed under the earlier lecture, was also available. Then comes Protection of Women from Domestic Violence Act 2005. According to the observation of the Supreme Court of India in the case of Indra Sharma versus K.V. Sharma 2013, the Protection of Women from Domestic Violence Act 2005 was enacted by Indian Parliament with the intention to provide a remedy in civil law for the protection of women from being victims of domestic violence relationships and thereby preventing the happenings of domestic violence in the society. By this observation of the Supreme Court of India, we can understand the objective of the Domestic Violence Act, with what an intention, with what an objective, with what a view the Protection of Women from Domestic Violence Act 2005 was enacted, and it also suggests the nature of the act, whether it is the part of the criminal law or the civil law. Supreme Court was of the opinion that the Protection of Women from Domestic Violence Act was enacted with an objective, with an intention to provide a civil remedy to women against any kind of domestic violence. It means that the remedy in the civil law, which was limited only to the option of divorce, was further expanded by the enactment of this act. Now, in addition to the remedy of divorce in civil law, many other options or many other remedies are made available by the enactment of the Protection of Women from Domestic Violence Act 2005. If we see the preamble of the act, it provides for more effective protection to the constitutional rights of women who are victims of domestic violence and for matters which are connected with or incidental to such violence. Section 2F of the act covers those women who have been in a relationship with the abuser, who have lived together with the abuser in a common household and are related by affinity, family, descent, matrimony, wedding, adoption or member of a joint family. So, all these women are covered within the sweep of Protection of Women from Domestic Violence Act. What does it mean? It means that the women who are sisters, who are mothers, who are widows, who are daughters, who are single women or living with the abuser are entitled to legal protection under the act, are entitled to legal protection under the act. So, all these women who are in any kind of relationship, they are entitled to the legal protection under the act. But it has also been held by the Madhya Pradesh High Court in the case of Kuldeep Singh versus Rekha that if the wife and husband have left the common household and they are not residing with parents, the domestic relationship ends with regard to the parents and the complaint cannot sustain against them because the domestic relationship is the condition precedent for the maintenance of the complaint under the act. So, according to the observation of the Madhya Pradesh High Court in Kuldeep Singh versus Rekha case, the domestic relationship is the condition precedent for the maintenance of the complaint under the act. The act also defines the term domestic violence, which was not earlier defined by any law. According to section 3, any act, omission, commission or conduct amounts to domestic violence if it harms or injures or endangers the physical or mental health, safety, life, limb or well-being of the woman or tends to do so by causing physical abuse, sexual abuse, verbal and emotional abuse or economic abuse, or if it harasses, harms, injures the woman with the view to coerce her or any other person related to her to meet out any unlawful demands for any dowry or other property or valuable security. So, very comprehensive definition of the domestic violence was made by section 3 of the Domestic Protection of Women from Domestic Violence Act, and it seems that each and every incidence of the physical, mental or sexual abuse to any woman could be included within the meaning of the domestic violence. So, all kinds of activities which in any way harms, injures the physical or mental health of the woman, they can be included within the ambit of the offence of domestic violence under the act. The explanation 1 to the section 3, physical abuse, sexual abuse, verbal abuse and emotional abuse, economic abuse have properly been explained in the act by the explanation. Verbal and emotional abuse encompasses within its ambit the insult, ridicule, humiliation, even name calling, insult and ridicule with regard to not having the child or male child, and repeated threats to cause physical pain to any person in whom the aggrieved woman is interested. So, the verbal and emotional abuse means any kind of such threat within its ambit, any insult, any ridicule, any humiliation, or even the name calling, insult, ridicule with regard to not having the child. It has also been included within the meaning of verbal and emotional abuse. According to explanation second, in determining whether certain conduct of a person constitute domestic violence, the overall facts and circumstances of the case shall be guiding factor. It seems that the scope of the definition given by the Act is very broad and extensive, that may cover almost all types of violence against women in the family. The economic conditions of women has also been made very sound by recognizing the compensation orders. Section 8 and section 9 of the Act sets up the system of protection officers and service providers. Section 8 requires the state government to appoint protection officers who are obliged and responsible for the enforcement of provisions of the Act. Section 9 provides for the duties and functions of protection officers as follows. See the duties and functions of protection officers appointed under section 8. The protection officers are duty bound or they are obliged to assist the magistrate in discharging his functions, to assist the aggrieved woman, to make a domestic violence incident report, to forward copy of such report to concerned police officer and to the service provider of the area, to make an application to the magistrate for issue of protection order on the demand of women, to ensure the legal aid to aggrieved women, to preserve directory of service providers of the area, to ensure the availability of safe shelter home for aggrieved women, to arrange for medical examination and medical attention to such women, to ensure the enforcement of court orders and to fulfill any other responsibility being obligatory for them. Section 9(2). According to this section, the protection officer shall be under the control and supervision of the magistrate and shall perform the duties imposed on him by the magistrate and the government by or under this Act. So, very comprehensive duties have been imposed over the protection officer. Then section 10 subsection 2, it is provided that for the purposes of the Act, any voluntary association or a company is permitted to register itself with the state government as service provider. Who will be the service provider? Any voluntary association or any company. It can register itself as the service provider. The service providers are empowered to record the domestic incident report and forward the copy of that report to the concerned magistrate and protection officers. And therefore, it is very unique feature of this Act that women are not required to go the police stations for filing the complaints or for recording the issue of domestic violence as the complaint. The protection officers and service providers, they are the middlemen and they are given the responsibility to ensure that the complaints of the domestic incidents of domestic violence may be made. This is very unique feature because in Indian tradition or in our society, particularly in rural areas, the women are not willing to go the police stations. This is one social stigma that the women, they do not want to go to the police stations, and therefore, the protection officers are appointed and the service providers are registered for the same purpose. This is also the power of the service provider to get aggrieved person medically examined and forward the copy of medical report to the concerned protection officer and the police station. To ensure the shelter to aggrieved women in shelter home. Now, section 10 subsection 3 gives the immunity to such service providers from any suit, prosecution or other legal proceedings for anything done or intended to be done in good faith. It seems that the justification behind the setup of protection officers and service providers seems to give the utmost weight and significance to the complaints of domestic violence and to provide the aggrieved women an alternative for seeking help and assistance other than the police. The Act provides for 5 remedies or remedial measures: protection orders, residence orders, monetary relief, custody orders and compensation orders. These are the 5 remedies being provided by the Act. A protection order is issued under section 18 to prohibit the respondent from number 1, committing any act of domestic violence, aiding and abetting the act of domestic violence, entering the place of employment or the place frequently used by the aggrieved woman or child, communicating with the aggrieved woman or child, alienating any assets, operating lockers or bank accounts belonging to both the parties jointly or to the respondent singly without the leave of the magistrate, causing any kind of violence to the dependents, other relatives or any person providing assistance and help to aggrieved woman or child, committing any other act specified in the protection order. So, there is a wide range of the securities being provided to the women under the protection order, and by getting the protection order, all the apprehensions, all the doubts, all the suspicions which were there in mind of the woman for not going to make the complaints of incidences of domestic violence, now all these apprehensions, all these doubts, all these suspicions have been removed by the legislature by providing for the remedy of the protection orders. Under section 19, the magistrate is authorized to issue the residence order. That is also one important reason for which the women were not interested to file the complaints of the incidences of domestic violence, that they were having the apprehensions in their mind that where they will reside if they make the complaints of the incidences of domestic violence. They will be made out of the home and there would be no place for their residence, and therefore, they were always making the compromise with these incidences or insulting incidences of domestic violence only for the reason that they did not have any option other than the house of the husband or the relatives to reside. This residence order is issued by the magistrate to protect the aggrieved woman or child from any disturbance in the possession of the shared household, meaning thereby now the woman, after making the complaint of domestic violence, cannot be removed from the house, to direct the alleged person for his removal from the shared household. Rather, the respondent, the person making the incidence of domestic violence, committing the domestic violence, would be made out of the home, to restrain the respondent and his relatives from entering any portion of the residence of aggrieved woman. This is also one important remedy. To prevent the respondent from isolating or disposing of or hindering the shared household, to contain the respondent from relinquishing his rights in the shared household, to direct the alleged person to provide an alternative accommodation of the same level to the aggrieved woman or to pay the rent for the same. In addition to this, the Act authorizes the magistrate to entail such supplementary conditions and pass any other ancillary direction necessary for the protection and safety of aggrieved woman or child. The magistrate may pass an order directing the concerned police officer to provide protection to the aggrieved or to assist in implementation of residence order and protection order. It may be pointed out that the residence order is an incomparable protective and remedial measure, particularly in Indian patriarchal society. Due to the limited property rights of women, the problem of residence is of immense significance in case of domestic violence. The Act provides for the grant of one more unique remedy, that is monetary relief under section 20. The magistrate is authorized to direct the alleged person for paying money to cover expenses made and losses suffered by the aggrieved woman or her child as a result of domestic violence. It includes the loss of income, medical cost, loss of any property, and the cost of maintenance of the aggrieved woman or her children. The adequacy, fairness, and reasonableness of monetary relief has been recognized as the basic requirement. The maintenance is also required to be consistent with the living standard of the aggrieved. So, the maintenance, the amount of maintenance is not only the amount of maintenance, but it should be in accordance with the living standard of that woman. So, it is very significant remedy being given by the Act to make the economic conditions of women sound and then to remove the imbalance of power and resources. The alleged person is obliged to make payment of such relief within certain period mentioned in the order. If he fails to pay with a specified period, the magistrate has authority to order the employer or debtor of such person to pay the monetary relief directly to the aggrieved woman or to deposit it in the court. The victim woman is also entitled for compensation order under section 22. This compensation order is intended to repair the damages for injuries caused, including physical injuries and emotional distress both. Damages awarded by the compensation order are given in addition to the monetary relief. There should not be any confusion that monetary relief and the compensation orders, whether both are should be given or not, or may be given or not. These compensation orders are given in addition to the monetary relief intended to recover the real expenses connected to the violence. The determination of compensation by magistrate is required to be rational, and therefore, it cannot be considered to be cogent, just and reasonable if it is granted in absence of any substantial material on record and as an outcome of cases. So, the compensatory order cannot be made only on the basis of cases. Custody order is also a remedy being provided by the Act to the aggrieved woman. Magistrate may grant temporary custody of child or children to the aggrieved woman or any other person making the request on the behalf of that woman. The magistrate may also specify for the visit of respondent to the child within the custody order, but if the magistrate thinks that the visit of respondent may be harmful to the interest of child, he may deny for such request. Section 23, power to grant interim and ex parte orders. The ex parte orders or interim orders may also be provided. Duration of orders is provided under section 25. Section 26 provides for relief in order suits, in other suits and legal proceedings. Section 27 provides for the jurisdiction, and section 28 provides for the procedure. All proceedings under section 12, 18, 19, 20, 21, 22, 23 and offences under section 31 shall be governed by the provisions of the Code of Criminal Procedure. What would be the procedure? The CRPC would be the procedure for the Act, but the court shall not be prevented from laying down its own procedure for disposal of an application under section 12 and section 12 subsection 2 and section 23. The provision of appeal has also been made in the Act, and the appeal goes to the sessions court within 30 days from the receiving of the order by the aggrieved woman or the respondent. So, the appeal, the provision for appeal has also been made, and that appeal can be filed by the aggrieved person within 30 days from the receive of the order. It seems that this enactment, the Protection of the Women from Domestic Violence Act, is very sound initiative on the part of Indian legislature to protect the women from domestic violence, and if it is implemented in real sense, that the women can be protected very well from any kind of domestic violence, and they can be given or they can be guaranteed the basic human rights. Thank you very much.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said but also in what remains unsaid. Today I will be reading one of the shortest instances of a short story that I have ever encountered, and indeed the very charm of this particular story that I am going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I will be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samarra. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samarra and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samarra to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to death. And death replied, it was not a threatening gesture. Rather, it was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samarra. See you in the next episode of Literary Snippet.